Good morning, everyone. Thank you all so much for joining us today. We're really pleased to have this wonderful program. On behalf of the American Constitution Society and our co-sponsor for this event, the National Bar Association, and our wonderful, generous host, Jenner and Block, I'd like to welcome you and thank you for joining us. This morning's program is The Power to Promote Progress, Opportunities and Limits to Prosecutors Seeking Reform. My name is Zanelle October. I'm the Vice President of Network Advancement at the American Constitution Society. For those of you who do not know, ACS is a national network of progressive lawyers, law students, scholars, and academics across the country, and some of our judges too. We believe that the law should be a force to improve the lives of all people. So we work for positive change in that regard. We focus on constitutional and legal questions, including race and the criminal justice system, which will be part of our discussion today. Before we begin, I'll give a quick housekeeping note. Today's event is eligible for 1.5 CLE credits in California, so please check with your jurisdiction for reciprocity or to receive that credit. Be sure to sign in at the table right outside of the room if you've not done so already, and be sure to check in at the table at the end of the program to receive your certificate. This morning, we're so lucky to hear from a distinguished group of people who serve or have served at various levels in state and federal prosecutor offices. My colleague Christopher later will introduce the panel itself, but I'll take this moment now to introduce our partner in this effort, National Bar Association President Juan Thomas, who's of counsel at Quinteros, Prieto, Wood, and Boyer. Juan is a friend of ACS, a friend of mine, and I'm pleased to introduce him.
Good morning. Thank you, Zanelle, for that kind introduction. Again, my name is Juan Thomas, and I have the honor of serving as the 75th President of the National Bar Association. And I want to thank our partner, ACS, for allowing us to partner with you this morning on this occasion. I'm a proud member of ACS, and I will tell you, because of my friendship with Zanelle and her involvement with the National Bar Association, she has become more involved in the NBA, and I've become more involved in ACS, and so this is a growing friendship and partnership that I'm very honored to be part of, and again, thank you for your leadership in allowing us to be here this morning. The National Bar Association is the largest association of African-American lawyers, judges, and law students in the country. We represent a network of over 65,000 lawyers across the country. We were founded in 1925, and this year in particular, one of my initiatives as president is to create more substantive programming throughout the bar year for our members. And so a lot of our CLEs and programs are held at our annual convention, but this year we're trying to do things throughout the bar year. And so this is one of those initiatives that we are launching here this morning to offer CLEs and substantive programming for our members during this week of the Congressional Black Caucus. I also want to introduce our interim executive director, who's a past vice president of the NBA, Cheryl Gray Evans, who's also here. We want to thank her for her presence, and all of our members who are here. And I'm very excited to be here today to be part of this conversation and this very important topic. And I also want to acknowledge our member who's going to be on the panel, State's Attorney from Florida, Miss Aramis, Ayala, who's here also. I want to thank her for her presence as well. She's a past regional director from Region 11 of the National Bar Association. I have the distinct honor of introducing our keynote speaker this morning, Mr. Ian Gershengorn. I will tell you, based upon his bio, he's a fantastic lawyer, very capable attorney, but I've just recently found out he's not a very good basketball player. He hurt his hand, and he may need a lawyer, so if anyone can help him with that, let him know after his presentation. But seriously, he's a partner here at Jenner & Block. I also want to thank Jenner & Block for hosting us this morning. But Ian is a partner here at Jenner & Block, where he chairs the firm's Appellate and Supreme Court practice. Prior to joining Jenner & Block in 2017, he was in the office of the Solicitor General, where he was served as the Deputy Solicitor General and then, of course, Acting Solicitor General of the United States. Prior to his service there, he was the Deputy Assistant Attorney General in charge of the DOJ's Federal Programs branch. In that role, he worked on the Affordable Care Act and other issues that were pertinent to our country. He is a graduate of Harvard undergrad and Harvard Law School. So with no further ado, please welcome our former Acting Solicitor General, Ian Gershengorn.
So good morning, everyone, and thank you, Juan, for that kind introduction. So when the folks at ACS asked me to speak here today, I told them I wasn't a prosecutor, and they said that's okay, and they offered me some suggestions on potential topics. And I was reading down the list, and I came to one entry that said Constitution Day and defending the Constitution. And I stopped right there because I thought that really is perfect for me. And that's because, unlike most people, I actually have an anecdote that's relevant to Constitution Day. Constitution Day, of course, celebrates September 17, 1787. And on that date, 230 years ago, the delegates to the Constitutional Convention finished their work. 39 delegates signed the Constitution, and the Constitutional Convention was adjourned. So interestingly, the full title of the holiday is not actually Constitution Day. The holiday grew out of Citizenship Day, which since 1952 had been celebrated on September 17th to recognize those who had become U.S. citizens. And then in 2004, Senator Robert Byrd proposed and Congress enacted legislation to change the name of the holiday to Constitution Day and Citizenship Day, which is what it is today. And under the statute, the purpose of the day is to commemorate the formation and signing in September 17, 1787 of the Constitution and recognize all who, by coming of age or by naturalization, have become citizens. The act also imposes two requirements. It requires all federal agencies to provide all of their employees with educational materials about the Constitution. So you see people walking around with their little pocket constitutions. Those come free of the federal government usually for federal employees. And second, on September 17th, every school that receives federal funds has to hold an educational program on the Constitution for its students. But in any event, back to my Constitution Day story. So as you heard, when I was at Federal Programs Branch at the Civil Division, I worked on the healthcare cases, and I argued the principal cases in the district court. And so my first argument in the Florida healthcare case was down in Pensacola, Florida, before Judge Roger Vinson. And Judge Vinson came out, and the first thing he said was the following: "This case raises a number of significant constitutional issues, and perhaps you may not realize it, but tomorrow marks the 223rd anniversary of the completion of all of the work by the Constitutional Convention. September 15th was a Saturday in 1787, and they finished their labors late in the afternoon or early evening and returned on Monday the 17th to go through the formalities and the final signing of the document. So we're marking the anniversary this week, and it starts, constitutionally, it starts there on September 17th. Counsel, I think we are ready to proceed." So to be totally candid, I knew at that very moment that we were in really, really big trouble. Because the plaintiffs were arguing that the Affordable Care Act exceeded Congress's power under the Commerce Clause and was beyond the taxing power, and that it violated the Due Process Clause. And our position was there was no constitutional problem at all. So I wanted the judge to come out and say, "Today is nothing to see here day." Or perhaps because we were arguing ripeness, it would have been better if he had come out and proclaimed that it was no need to do today what we can put off till tomorrow day. But he didn't do that, and when he announced that it was Constitution Day, I knew we were in for a rough time. In any event, as we mark Constitution Day and as we celebrate the Constitution, I thought it might be worth briefly considering what it means to defend the Constitution. So sometimes defending the Constitution means seeking to protect individual rights in court. And I think that's the notion that many of us have in mind when we think of defenders of the Constitution. It is, of course, Thurgood Marshall arguing Brown v. Board of Education. It's Clarence Gideon arguing for the right to counsel for indigent defendants. It's Edith Windsor seeking to vindicate the rights of same-sex spouses. It means the ACLU defending the First Amendment. It means LDF and MALDEF and Lambda Legal and all the many, many other groups that fight in court each and every day to protect individual rights. And it means Miranda and Loving and Brady and Reynolds and Lawrence and Obergefell. It means fighting for the right to vote and the right to speak freely and the right to worship. And it means working to protect the rights of criminal defendants. It means, in short, working through the courts to protect and give real meaning to the individual rights set forth in the Constitution. And that's an extraordinarily important way to defend the Constitution. But that's not the only way, and it's not the way that a government lawyer often defends the Constitution. So I spent a lot of time in the last 8 years engaged in constitutional litigation at the SG's office and at the Federal Programs Branch, and I worked on a lot of important administration priorities. As was mentioned, I worked on the defense of the Affordable Care Act. I worked on cases resisting congressional subpoenas, opposing religious objections to contraceptive coverage, and defending President Obama's immigration policies. And I worked on a lot of cases that had a more nuanced and difficult relationship for the administration. I helped to defend against the habeas petitions for Gitmo petitioners. I defended against allegations that there were American citizens on a targeted kill list. And I worked on the defense of the constitutionality of the Don't Ask, Don't Tell statute. The list goes on and on. And that experience has influenced, I think, the way I think about and what my view is of what it means to be a defender of the Constitution, especially as a government lawyer and especially at the Department of Justice. Because in all of these efforts, I thought of myself as a defender of the Constitution, but I was often opposing, not supporting the expansion of individual rights, and I was often opposing, not supporting, court intervention. So how does a government lawyer defend the Constitution? Well, I want to mention briefly 3 ways. So first, defending the Constitution as a government lawyer sometimes means not asking the court to fix things, but instead relying on the democratic process to resolve the issue. Now that can be really, really hard, especially for political appointees who don't like the policy that they're defending. It's tempting in that situation as a government lawyer defending the government defending the statute or regulation that the administration opposes, simply to concede the litigation. But defending the Constitution means respecting one's constitutional role, and the lawyers at the Justice Department don't generally repeal statutes or regulations by conceding their illegality in court. It's for Congress or for the agency to repeal the policy. Conceding away federal power today may hamstring the federal government tomorrow when it needs that power. And conceding a case today may leave the executive branch under judicial supervision for decades to come. That lesson is hard for political appointees. There's a tendency to want to move quickly. Appointees are only in government for a brief time. They want to get the president's agenda in place, and they don't really want to spend their time defending the prior administration's policies. Indeed, they may often want to get rid of those policies as fast as they can. So from my time at Justice, the Don't Ask, Don't Tell statute is a perfect example. President Obama opposed that statute, and appointees at the department would have preferred not to defend it. But we defended it out of respect for Congress's authority over military affairs, and out of respect for our role as government lawyers as defenders of congressional power. And at the same time, we worked hard to encourage Congress to repeal the statute, which of course it eventually did. So in that instance, to defend the Constitution, we as government lawyers trusted the democratic process. So a second way government lawyers sometimes defend the Constitution is to argue for expansive views of federal power. Now, that's not because the federal government always gets it right, to be sure. And it's not because the federal government always uses its power wisely, to be sure. But rather, it's to ensure in areas like healthcare and immigration, in areas involving foreign affairs and military conflict, that the government has what it needs to address the problems we face. Again, this can lead to difficult and controversial positions. The Justice Department routinely, for example, defends broad assertions of federal power in the national security space. In my time at Justice, this meant defending the use of drone strikes. It meant defending the constitutionality of military commissions to try individuals connected to the September 11th attacks. The government lawyer defends the constitutionality of those military decisions, not because the lawyer necessarily believes the decisions are right, but rather because it's the lawyer's constitutional role to create space within the bounds of law to give the democratically elected branches of government the flexibility to protect our country. And the third way that government lawyers sometimes defend the Constitution is by arguing that courts have a much more limited role to play. I think of cases like Fast and Furious and House v. Burwell. Those were cases in which the House of Representatives sued the executive branch in court. So in Fast and Furious, the House was suing to get certain documents over which President Obama had asserted executive privilege. And in House v. Burwell, the House had sued to stop the executive branch from making certain payments to insurers that were needed to make the Affordable Care Act work as it was intended. In both cases, government lawyers argued that notions of separation of powers required federal courts to stay out entirely. They had no role to play. We argued that the Constitution required political battles between Congress and the president to be fought out in a political arena, not in a courtroom. Now, all of this is not to say that these are the only three ways government lawyers defend the Constitution. I argued in the court to protect and expand voting rights, and I worked on briefs supporting same-sex marriage and opposing state efforts to close abortion clinics. And the President and Attorney General Holder made the constitutional judgment to expand individual rights when they elected not to defend DOMA, the Defense of Marriage Act. But it is to say that government lawyers often defend the Constitution not by seeking to expand access to the courts, but rather by arguing that certain disputes are best left to the political branches rather than to be resolved in a judicial arena. So understanding how a government lawyer defends the Constitution has implications for the rest of us. It means if we are to defend the Constitution, we must encourage vigorous debate, vigorous dissent, public debate, and political engagement. Because often the government is going to win. A court will uphold a policy we don't like, the federal government will be given an expansive power, and a court will decide to stay its hand and leave things to the political branches to resolve. And even when the government loses, we find that the courts are not the full answer, as the folks in this room may know all too well. Courts may move too slowly, they lack institutional competence sometimes, they may be hostile forums, and they may lack power as a practical matter to settle an issue by judicial decision. And when that happens, when the critical issues affecting our country are left to the political process, dissent, debate, and political engagement are critical. Of course, that's not a flaw in the Constitution, that's a feature. The framers anticipated dissent. They expected public debate and they welcomed public engagement. They expected the citizenry to be a check on the government, and they expected citizens to achieve important gains, not just in courts, but also democratically. And so as we mark a bit belatedly this Constitution Day, let me close with this. The Constitution is an amazing document, but it's not a perfect one, and it remains a fragile one. So be a defender of the Constitution. Continue to fight in courts for individual rights. Continue to do justice in your constitutional role if you're a government lawyer. And above all, continue to dissent, debate, and engage in the public sphere, both to preserve all that makes the Constitution great and to accomplish all that the Constitution still leaves undone. Thank you very much.
At this time, I'll ask that our panelists join us up front while I introduce my colleague, Christopher Wright DeRocha. Christopher handles our criminal justice portfolio at ACS, among other things. I also want to take a moment to flag for you that ACS and BA is a sponsor of this as well. In California, 56 out of 58 of the district attorney seats are up for election in 2018. And so we are really focused on the role of prosecutors there as well as around the nation. And so we have a series that we are doing called Prosecutors to Change the World. Help want it. And flyers on the table outside. So I hope that you'll grab one and share with your networks. We'd love to have you join us. And now I'll introduce Christopher DeRocha. Right, DeRocha.
Thank you, Zanelle. Good morning, everyone. As Zanelle mentioned, my name is Christopher DeRocha, and I serve as the Director of Policy Development and Programming at the American Constitution Society. I'd like to echo my colleagues' thanks for joining us today, and I'd also like to extend my thanks to the panelists for being here. In the past few years, often in response to incumbent chief prosecutors' failure to reflect the values and needs of their constituencies, cities and counties across the country have elected self-described progressive prosecutors. Recently elected prosecutors like Kim Fox in Chicago, Mark Gonzalez in Corpus Christi, Kim Ogg in Harris County, and State Attorney Ayala, who's here with us today, join the ranks of other reform-minded prosecutors like acting DA Eric Gonzalez in Brooklyn, Cyrus Vance in Manhattan, Pete Holmes in Seattle, and James Stewart in Shreveport. In addition to elected leadership, reform-minded attorneys are also serving as line prosecutors in federal and state prosecutors' offices across the country. While prosecutors with progressive values are not new, more and more they are committing to undertaking reforms not usually associated with those in law enforcement. These attorneys, many of whom are men and women of color, are seeking to leverage their roles as prosecutors to combat racial and economic disparities in the criminal justice system. Among other things, these prosecutors are focused on the need to reform the cash bail system, decriminalize low-level offenses like marijuana possession and so-called quality of life crimes, and bolster support for undocumented immigrants. They seek to establish and give meaningful weight to conviction integrity units, hold police accountable for unjustified uses of force, pursue alternatives to incarceration, and support and protect members of marginalized communities. While reform-minded prosecutors cannot solve all the problems with our criminal justice system, they are key allies in any reform effort. It's the reason why reform-minded lawyers and law students, even those who don't think of themselves as the law and order type, should consider the difference that they might be able to make by serving in a prosecutor's office. And it's one of the reasons why we're here this morning. I now have the distinct pleasure of introducing our moderator for today's discussion, Roger Fairfax. Dean Fairfax is the Jeffrey and Martha Cohn Senior Associate Dean for Academic Affairs and Research Professor of Law at the George Washington University Law School. He teaches courses in criminal law, constitutional and adjudicatory criminal procedure, criminal litigation, and seminars on the grand jury, white-collar criminal investigations, and criminal justice policy. Among his many relevant published works, Dean Fairfax has written about the smart-on-crime prosecutor, as well as prosecutorial nullification, the idea that prosecutors might decline meritorious prosecutions because they disagree with the law or its application in a particular case. Concepts that are particularly relevant to today's discussion. Earlier in his career, he served in a number of prosecutorial roles, including as a federal prosecutor in the Public Integrity section of the DOJ's Criminal Division, and as a Special Assistant U.S. Attorney in the Eastern District of Virginia. As you can see, he's an ideal leader for this conversation. So let me now turn it over to Dean Fairfax to introduce the rest of our panel.
So good morning. My name is Roger Fairfax, as was mentioned, and I'm very honored to be here. I want to thank the American Constitution Society and the National Bar Association and Christopher for organizing this panel on such a timely and urgent topic, and for assembling such a wonderful group of distinguished panelists. And I want to thank all of you for being here as well to join in the discussion. I will introduce each of our panelists and then ask each of them to frame the issues with opening remarks. We'll engage in a discussion among the panelists, and then we will be sure to save time for Q&A so that those of you in the audience can join in the conversation. Starting to my immediate right, we have Sonja Ralston, who is an appellate prosecutor with DOJ's Criminal Division, where she handles federal criminal cases throughout the United States. She has argued in all 12 regional courts of appeals and has participated in numerous cases before the United States Supreme Court. She handles cases in all criminal subject areas, but has a particular expertise in cases involving forfeiture and restitution. During her time in the DOJ Criminal Division, she's taken two details away from appellate work, one of which sent her to the West Coast to serve as a Special Assistant United States Attorney with the U.S. Attorney's Office in Los Angeles, and also as counsel to the Assistant Attorney General, the former Assistant Attorney General for the Criminal Division, Leslie Caldwell. In 2014, she received the Assistant Attorney General's Award for Outstanding Contributions by a New Employee, and is a frequent lecturer on appellate advocacy and legal writing at the National Advocacy Center in South Carolina.
She's a graduate of Duke University Law School, a member of the ACS Next Generation Leaders Program, and she clerked for Judges David Tate on the D.C. Circuit and Judge Guido Calabresi on the Second Circuit before joining the Department of Justice Honors Program. Next to her, we have Aramis Ayala, who is the state attorney for the 9th Judicial Circuit of Florida, and she was elected in November of 2016. She earned her undergraduate degree from the University of Michigan, and her master's degree from the University of Central Florida, and her law degree from the University of Detroit Mercy School of Law. Before her election as state attorney, the first African-American ever to be elected as a chief prosecutor in Florida, she had worked as an assistant public defender and as an assistant state attorney, and so has experience on both sides of the V, so to speak. Her election and tenure as a state attorney have garnered many headlines, both because of her decisive electoral victory and her well-publicized stance on seeking the death penalty and her subsequent battle with the governor of Florida over that issue. Immediately to her right, we have Thuru Vignaraja, who is a partner at DLA Piper in Baltimore and previously served as Deputy Attorney General in the state of Maryland. And he's a native of Baltimore and studied at Yale College and Harvard Law School, where he served as president of the Harvard Law Review. He clerked as well for Judge Calabresi on the Second Circuit, and then clerked for Justice Stephen Breyer on the United States Supreme Court. He then went on to serve as a federal prosecutor, the U.S. Attorney's Office in Maryland, and rose to Chief of Major Investigations in the Baltimore City State's Attorney's Office before being named Deputy Attorney General in Maryland. He has taught constitutional law and crime policy at Johns Hopkins, the University of Baltimore Law School, and the University of Maryland Law School, and recently declared his candidacy for State's Attorney for Baltimore City. And last but not least, we have Lenese Herbert, who is a professor of law here in town at the Howard University School of Law, where she teaches evidence, criminal procedure, criminal law, social media in the law, and administrative law. Prior to law teaching, she practiced extensively as agency counsel for the U.S. Department of Transportation, the CFTC, and also as an AUSA here in the District of Columbia in both the criminal and civil divisions. She's a graduate of Howard University and earned her law degree at UCLA, and co-authors a number of books, including Constitutional Criminal Procedure, and is a contributing author to a book entitled Race to Injustice, Lessons Learned from the Duke Lacrosse Rape Case. Her scholarly work also has appeared in a number of law reviews and journals, and she's made many media appearances in various international, national, and local print media and television and radio outlets. So if you will please join me in welcoming our distinguished panel. So, Sonja, since you're closest to me here, I'm going to ask you to start by just taking a few minutes to perhaps help frame some of the issues we're going to be discussing this morning.
Okay. We need to use the microphone.
Yes.
Is it on? Oh, it is. Okay. Good morning. This is a really tough but important question for all of us to be considering, both as prosecutors and as citizens, because the criminal justice system speaks for the people. It's, I think, the only part of the legal system where, we're not just going to court to vindicate individual rights, that it's the individual defendant on the one side and the people or the state, the government on the other side, where, we don't represent a particular client, but we're here to represent everyone. And I think that carries very special responsibilities with it, that, you have to balance competing interests as a prosecutor in a way that as a litigator representing a private client, you don't always. So, yes, you need to be vigorously advocating for your client, but that doesn't always mean doing everything that you can to win. Sometimes that means, looking for the just solution, which may not be a win. It might mean conceding error on appeal, which is what I do. I practice appellate law. It might mean looking for a settlement or a plea bargain where you're bargaining down from the most serious count that you might be able to put in an indictment and take to a jury, because maybe the mandatory minimum isn't the right choice for this case, for this defendant, for these circumstances. And balancing those factors takes a lot of judgment, but it also takes an institutional commitment to seeing that there is a balance, that it's not a one-way or one-sided endeavor. And that's the kind of thing where institutions are led by leaders, obviously, but they're comprised of individuals. And as an individual prosecutor, every person who comes to the prosecutor's office has the opportunity to be a part of that conversation, to sit on an indictment review panel, to say, asking hard questions about why are we bringing this case? Why were we investigating in this neighborhood? Why is this marijuana prosecution the right use of our resources? And having people in the room just to ask those questions goes a long way to ensuring that the prosecutions that are being brought are just and reasonable, that we're obviously never going to catch every criminal in the country. We're never going to put find justice for every victim. But, we need to be making sure that we are targeting our efforts and our resources fairly and appropriately, so that we're treating people who have done the same thing similarly, but also to be making sure that we're taking into account the circumstances that have put people into the situations where it's been told to me by, I think, a number of defense attorneys who say that, I don't deal with people for the best day of their lives. And that's true. Nobody ends up in my office or on my docket for something that they did on the best day of their life. And it's important for us to recognize that, to say that people are not their crime, that there can be justice to hold people accountable and responsible and have them take responsibility for what they've done, without saying forever, this is the thing that defines you and this is who you are. There are no perfect answers. It is about seeking this balance. It's about saying, what can we do for the community versus how can we treat the individual as an individual. And I would just say in closing that for anyone who is a law student or a young lawyer considering, looking for a new path, that you should consider being a prosecutor, because it's important to be in the room. If you're not there, someone else will be. And bringing the perspective that you can bring is an important one to have in the room, to have that voice, because the institution is comprised of its individuals, and the more individuals who share the values of justice and fairness, the better off the institution will be.
Thank you, Ms. Ralston. So State Attorney Ayala, if you could share your thoughts as well.
Thank you, sir. Good morning, everyone. Very glad to be here. What I'd like to say is that forums like this and conversations are definitely necessary when we're in this point in time, because of where we are in the criminal justice system. The reason that it's important, because just as important as reform is public opinion of reform. And if we are not well aware of what the realities are in our criminal justice system and what we're producing or failing to produce, we cannot create solutions that deal with the problem. The concept of garbage in and garbage out is very real. And if we are instituting garbage within our criminal justice system, we cannot end up with what we're all hoping for, and that's increased public safety. So the biggest thing that we have to correct the minds of people is to think that reform has anything to do with the favor to the defendant or the favor to criminals. This is about public safety. This is about doing what is right. Reform prosecution is the intellectual response to a problematic system in criminal justice. That's exactly what we're doing. So when you understand that you're looking at policies that are often fear-based, that are often based upon feelings, and when we as practitioners fail to utilize the research and the data that has been gained from institutions that we respected enough to pay tens of thousands of dollars for and paying on law school loans for all of this time, that at some point we have to value that information and use it for practice. So as prosecutors, one of the most important things to do is understand that it's not about what we feel, what we think, it's about what we know in humanity. We can never eliminate the fact that our system is created and comprised of human beings that need to be treated as such. And when we begin to treat people like human beings, we will produce more humanity in the system. When we begin to have a system as prosecutors that we are promoting and administering justice, we will be respected because we're producing respectable results.
Thank you, State Attorney Ayala. Mr. Vignarajah.
Good morning, everyone, again. It's a real privilege to be here, and I want to start actually by sharing a story involving the judge that both Sonja and I had the privilege of clerking for. Guido Calabresi is this revered judge on the Second Circuit, the former dean of Yale Law School, and one of my very, very early memories of clerking for him involved a case that was on appeal where a lawyer from the Justice Department was on one side and an asylee seeker was on the other. And it was a circumstance where the person who was seeking asylum was using the wrong procedural mechanism, and it was very clear that the court was going to ultimately have to rule against that person. And at some point, the prosecutor, the attorney, just like Sonja, stood up and was asked a question by Judge Calabresi and said, well, you can't use this route, but could you use this other procedural mechanism for the asylee seeker to obtain relief? And the attorney said, yes, in fact, you could. In fact, I've advised the asylee seeker that they should seek that. We have to oppose this particular petition, but there is this other mechanism that's available for them to accomplish the same purpose. And Judge Calabresi said something, it was my first or second month clerking, and I'll never forget it. He said, ma'am, I think it's really nice for you to remind all of us that you don't work for the Department of Deportation, you don't work for the Department of Convictions, you work for the Department of Justice. And he actually wrote a letter of commendation to the Justice Department for the fact that she had done that. And that sort of stayed with me. It was the power of the prosecutor, the power of the government to use their judgment, to use their discretion to make sure that justice happens in each individual case. Even as Ian had said, you sometimes defend the position of the government. In any particular case, you can mete out justice in a way that is measured, that takes account of the individual circumstances of that particular case. What I thought I would do in these opening remarks is identify a couple of major areas where prosecutors can make a real difference. Because the authority of prosecutors to decide who to charge, what plea offer to make, whether to take a deal, whether to not take a deal, whether to disclose evidence, whether to not disclose evidence, that's all of the things that defense attorneys have to react to. So in many respects, prosecutors are in a better position to protect the constitutional and civil rights of defendants than defense attorneys are. Those decisions that they make end up defining what the defense attorneys have to respond to. I thought it would be helpful just to identify 4 areas where I think prosecutors can make a big difference. First is the ways in which they exercise their discretion, and I'll elaborate on that one in just a moment. The second is how they work with and collaborate and give guidance and feedback and pushback to their law enforcement partners. The third one has to do with preventing injustices from happening in the first place, which we unfortunately know are real and we have to do more to prevent. And the fourth one, is advocating for system-wide reform. I thought in my opening remarks I would just focus on that very first one, and then maybe as conversation proceeds we can talk about some of the others. In the context of exercising prosecutorial discretion, I think it's really important, especially for a lot of the young lawyers in the room, to understand there's different ways in which this can happen. There are circumstances where prosecutors can say, you know what, we are prosecuting victims of addiction. We are prosecuting victims of trafficking. This is a poor use of our resources. In a place like Baltimore, where we have record-breaking homicides and record-breaking violent crime, the idea that prosecutors are dedicating their energies to pushing through the docket these low-level drug offenses, it's really a poor use of resources, right? Among other things, it's that there's a tacit decision every time you prosecute somebody for simple possession of marijuana or heroin. You're making a decision to take resources away from the people that are prosecuting carjackers and shooters and killers. But the other ways in which you can exercise discretion is understanding that there are certain categories of crimes that have impacted both communities of color and communities of poverty in ways that prosecutors can help remedy. In Baltimore City a couple years ago, it's a city that's about 64% black, 84% of trespass arrests were of African Americans. 93% of loitering arrests were of African Americans. Those categories of crimes are tailor-made low-level offenses that were ravaging communities of color. And so when prosecutors decide where they want to spend their resources, where they want to dedicate their prosecutors, it's really important to understand that there is both the decision not to advance prosecution and policing strategies that do have disproportionate burdens on communities of color. It's also to understand that there are categories of crime like drug possession that really are prosecuting victims of addiction. A couple years ago, there were 6,600 arrests for simple possession for drugs in Baltimore. Baltimore launched a program to much fanfare that followed the LEAD program in Seattle. Have you guys heard about that? It's a program where it's called law enforcement assisted diversion. Even before the person enters the criminal justice system, you divert them out of the system. It's sort of a pre-arrest diversion. The capacity for that in Baltimore is 60. So if you take account of the number of people that are being arrested for simple possession that need to be treated through a public health paradigm, not a criminal justice one, and you recognize the deficit in the capacity, that is a place where prosecutors can make a difference too. And I wanted to give you guys both, some high-level guiding principles as well as some concrete examples of why I think we should, make sure that we are celebrating prosecutors like the ones on our panel today for what they are doing, but also understand that there are prosecutors in the rank and file, which I hope many of you guys will join, that can make a huge difference as well. Reminding yourselves always that it's not about convictions, it's not about deportations, it's not about your track record, it's about justice.
Thank you, Mr. Vignaraja and Professor Herbert.
Well, thank you for having me here today. I'm so thrilled to be here. I feel like I want to join the audience because I've heard so many good things already on the panel. I won't repeat those things, but I will add the following. When I was a young lawyer, I decided to take on a mentee. The mentee was from a program in DC called For Love of Children, sort of a Big Brothers Big Sister program for foster kids. And so my mentee at the time was 10 years old, and she was very happy to have a lawyer for her mentor. But I transitioned then from the Commodity Futures Trading Commission to the U.S. Attorney's Office in D.C. It was a big deal because the U.S. Attorney at the time was Eric Holder, and he came into office with much fanfare. There was an expectation that with his appointment, he would, in fact, do something that looked more like seeking justice in the District of Columbia than some of his predecessors. And so when my mentee was asked, at my one of the parties associated with my swearing in, what does your mentor do? She said with a big smile, well, she's a persecutor. And I'll never forget that because apparently there's a perception out there that the only thing prosecutors can do is persecute. And it was particularly important for that sort of malapropism to occur because it reminded me of how very important it was for those who are touched by prosecutors. It's very important for them to feel as if they are being treated justly, fairly, equally, respectfully. And so as I started my new position, I took that terminology with me and tried very hard not to be a persecutor. I can't say that I was always successful. One of the challenges I think that we may touch upon today is why is it so hard to do justice, to be a reform prosecutor, as a prosecutor? So I'm not convinced I was as successful as I should have been and could have been, but certainly the goal was not to be a persecutor. Another story about a young person in my past. This one was a young West Point enrollee, and now he is an officer. when I went to West Point for the first time to sort of help him sort of get settled into his dorm room, I grabbed a dictionary from the bookstore. I love traveling and I love grabbing dictionaries wherever I go. And one of the things I learned was the difference between an officer and the rest of those who are in our military. And one of the things that fascinated me in that definition of an officer was that they're paid, and I apologize if I get this wrong for those of you who are in the military, familiar with military law, but they're paid to think. And sometimes that thinking requires them to, in fact, disobey an understanding of what an order should be. This notion of you get to make a decision that looks like something separate and apart from what others are doing, and you are almost required to exercise your judgment, your discretion in situations that require your leadership. I love that definition. And I started to think of myself along the lines of something akin to an officer when you think about the notion of justice, this understanding that there needs to be an intellectual engagement with the job. This is not about reflexively doing anything. And one of the hardest things about being a prosecutor, particularly if you're going to be a successful one, is that you're going to be measured against your win-loss records. And I'm not ever going to say it's unimportant. It certainly is important, if for no other reason than to sort of be seen as an equal among your peers. But certainly this notion of thinking through to a useful decision, infusing your thought process with the concepts of justice, being very clear about what goes into the system can in fact be troubling, problematic, and we don't have to question it. We know it for sure. All of that makes a difference in who you choose to be as a prosecutor, who you choose to be as a leader, and who you choose to be as someone who wants the system to respect the individual, and you want to be the prosecutor who is in fact affecting justice. I know many of us are hired as, and maybe even forged as, hammers, but we know, or we soon learn, that not everything is a nail. And so the ability to be nuanced in our approach is critical. Certainly, when people show up in your offices, it's not the best day of their lives. And I like to say to my students all the time, on any given Sunday, the person who shows up in your office could be the victim, could be the defendant, could be the officer, it could be opposing counsel. You just never know. And so understanding the vagaries that exist in the realm, and understanding that when folks show up in a prosecutor's office, it really is about you stepping outside of that staid, cold role and opening up your eyes to what, in fact, is existing and what exists in the realm. We are the ones who will affect the change. I know it's important to look at judges. I know it's important to assign responsibility to defense counsel. But as I was told in law school by a very good friend of mine who now serves in the alternate public defender's office in LA, the prosecutors have the real power in the courtroom. And to the extent that we have that power, understand we have the responsibility to exercise it responsibly. And so if we are clear about what it is that's required, if we are clear about the realms in which we operate, if we are clear about the social science, if we're clear about the statistics, if we're clear about all sorts of things, we, I think, have a better chance of affecting true reform. Otherwise, we're just in an assembly line trying to rack up convictions and serving no one but our own agendas and ourselves, and not necessarily even ourselves if we are, in fact, reform-minded. So I'm very happy to be here again. I look forward to the discussion that we're about to enjoy.
Thank you, Professor. And so there's a lot to unpack, and you all set the stage very nicely. Let me start with a question about what drives this wave, and that would be the elections that lead to the entry into office of reform-minded prosecutors. You know, obviously, on the federal level, U.S. attorneys are appointed by the president. confirmed by the Senate, and it should be expected that they would reflect the enforcement priorities of the President, of the Attorney General. But as many of us know, most prosecutors in this country are elected. And you know, what's interesting is to think about how campaigns, political campaigns, might look going forward if, in fact, this movement toward reform-minded prosecution gains traction. There's a scholar at Wake Forest Law School, Ron Wright, who's done some interesting work on prosecutor elections and some of the barriers that candidates have with regard to conveying to voters what their priorities are and what resonates with the electorate. And so I'm interested in hearing perhaps a little bit about how we think prosecutor elections may look over the next 5 to 10 years as this becomes a greater part of the political conversation. Again, I acknowledge that we have one candidate for office, and so I don't want to make him feel uncomfortable. But if we could address the question of what these campaigns might look like, and I will ask each of you to comment on that.
I'll start. No, you know, I think it's a fair question, and I actually don't. I don't think it's a hard question in the sense that it doesn't make me feel at all uncomfortable. One of the risks of the fact that a lot of these offices are elected is that the particular circumstances of a particular city or a state would tend to shape people's views, and I think that's a real risk. Because I think the people on this panel, the people that are committed to both the justice reform effort as well as, you know, making sure that our streets are safe, have to abide by a set of principles that doesn't get buffeted by time. In Baltimore City, we are facing quite literally the worst homicide surge and crime surge in this city's history. It's a time when there are city council folks that are advocating, along with the mayor, along with the police commissioner, for a return to mandatory minimums. Very different than the mandatory minimums that were put in place in the 1980s. But there is a reality that when you have a circumstance where crime is spiking, it becomes harder to say we can't go back to the zero tolerance, mass incarceration, mandatory minimums policies that failed us in the early 1980s. And I think it's really important to appreciate that there is a temptation to fall for that, to say, gosh, crime is high, we got to go back to being a hammer and treating everything like it's a nail. I think that's a real danger. And I think one of the reasons why it is important, as was just mentioned a moment ago, to encourage people to support the momentum is to make sure that there is some resistance to the tide when crime goes up. You'd like to think that that's an aberration, but what if it's not? And I think it's really important, especially at the local and state level, for us to come up with an antidote as progressives to what Donald Trump and Jeff Sessions and Rudy Giuliani think is the only way to bring crime down, right? There's this formula that they will put out there that if you're tough on crime and you prosecute everyone, crime will go down. And they point to examples and they say that's the only way it can be done. And I actually think it's really important when crime spikes for us to show that there is another way, that we can both bring crime down and make the system more just. And so I'm optimistic that this momentum will carry forward, even when it becomes hard to stick to those principles.
State Attorney Ayala, you obviously most recently came through a campaign successfully, and so I'd be interested to hear your perspective on that question.
Thank you. What I could say is just when I heard the question, it made me realize that what's going to happen is going to be an increase of four things. The first thing, unfortunately, it's going to be an increase of partisan politics, because right now we're separating between reform and everyone's saying, oh, this is, hug a thug mentality, like, you just care, you want to fix everybody, you want to do social work from the prosecutor's office versus, as was said, the tough on crime. So the problem with that is that when you start politicizing justice, that creates an injustice itself, right? Because you can't look and say, oh, we're being fair, but I have this theological thought here. I have this theology here that's going to impact you, your life, justice, your humanity, how you're treated. That's one of the concerns. The second thing that it increases is community awareness, and this is a good thing. Communities have not been been overly involved in prosecutors' races historically. It's just another box that someone marks. You know, they look at the President of the United States. If you look at the numbers of and the turnouts in prosecutors' elections and who actually votes, it has been historically relatively low. With this trend going on, you're going to have people much more involved in the political in the political scheme of prosecutors. And the third thing that it does is it increases accountability. When you look at the history of elected prosecutors and district attorneys throughout the country, most of them have held their seats for multiple terms, some being in 20, 30, 40 years until they decide to leave. This now increases their accountability because the awareness of the community has increased. They now have to answer to people and not just show up and threaten someone not to run against them. They have to have a legitimate platform every time they run, and they're going to have to answer to it every 4 years later, depending on how long the term is. Finally, what it's going to do is increase the awareness of the complexity of our system. See, our system is not just about prosecutors. We can sit in this room all day long and come up with the best ideas of what prosecutors should do. But if you think about it, your thumb can't operate on its own. Your pinky can't operate on its own and be effective. You have to use your all parts of the hand. You've got to consider corrections. You've got to consider policing. You've got to consider defense work. You have to consider the judiciary. You have to consider prosecutors. So we are only as effective as we are able to affect those and impact those around us. New elections with reform, it makes us see not only do I have a good idea, but do I have a good idea that's going to work in the frame and in the landscape of where we are. It has to work and not just be a good idea. So I think that the level of accountability and what isn't increasing as far as conversation is very, very, very productive. While it does have the negative component of increasing the partisan political aspect of it, it gets us talking, and when we start talking, it makes us accountable.
Thank you. So I want to take a bit of a different spin on that same question. So, you know, as I said, most chief prosecutors in this country are elected, but most prosecutors are not chief prosecutors, right? They're line attorneys, and they are tasked with implementing the enforcement policies as set forth by the chief prosecutor. So what do you say to that line attorney who comes to a staff meeting and is not hearing the message that we just heard from State Attorney Ayala, which, you know, obviously would empower them to pursue those particular enforcement strategies, but instead is hearing what we had become used to hearing from chief prosecutors pursuing sort of a tough on crime strategy? What do you say to the line prosecutor who doesn't have the leadership on that issue in his or her own office or jurisdiction, and what that line prosecutor can do? Now, obviously, you can run against the chief prosecutor, as we've learned, but before you're able to do that, what can you do on a day-to-day basis to help advance justice in individual cases?
So I remember when I first became a law professor, I got a call from one of the an alumnus from the law school I was just hired to teach at. Didn't know me, you know, at all, hadn't met me. But one of the things that she asked was, "You used to be a prosecutor. I'm having a really terrible time in my office because the police officers I'm working with are essentially involving themselves in a lot of conduct I consider to be questionable, and I don't know what to do." One of the things I'm very clear about is when I was a prosecutor, I had the benefit of being in an office where reform seemed to be job one. There seemed to be, there was an absolute active connection with the community that was fostered, tweaked, enhancements were put in place, all sorts of things were in position where it was easier for me to do the job that I thought needed to be done and that I was hired to do. And one of the things I would say, particularly to young attorneys, because I think that's a tough place to be a reform attorney, only because you don't know what you don't know. And there are possibilities to be a reform prosecutor and all at every step of the way, but you don't necessarily know. You've not yet perhaps papered a case. You've only done appellate work. You just don't yet know. I would say first and foremost, and this is what I said to that young attorney who asked me, I would wrap myself in the flags. And what do I mean by that? When you have to push back against law enforcement, particularly when you're young, particularly when you don't have sort of leadership at the helm, one of the things I suggest is you wrap yourself in the language of the law. And as you know, reasonable minds can do and will differ on interpretation and the application. And so the ability to say to law enforcement in that situation, actually, no, I think this is insufficient with respect to the probable cause that we have. What was your reasonable suspicion? What is that based upon? It's not clear to me that, in fact, this was anything other than a hunch. And you can do things because you have to be careful about your relationship. Again, you're right. The pinky can't do it alone. And so being clear about your relationship with the other elements of this realm, the criminal justice system, you want to keep a good relationship with your officers. And so one of the ways you do that is absolutely make it very clear that you are doing your job when you say no, when you decline to prosecute a case, when you decide that perhaps some sort of diversion is necessary as opposed to just a hardcore prosecution. Being very clear about the standards, repeating the law over and over and over again sends a very clear message. As you develop your reputation in the office and your experience, one of the things that will sort of come to pass is that officers will decide whether or not they want to work with you. And the ones who are interested in standards and quality, and they see that you are strong enough, even in your, your sort of neophyte status, you're strong enough to absolutely stand for the law and justice, they will start to flock towards you. And the ones who aren't interested in that level of accountability, your pushback, they will find other prosecutors to work with. I'll never forget when I was in the sex offense section where we basically investigated our own cases, and the officers work with you in sort of, currying the evidence, investigating, getting the witnesses in the grand jury, and then prosecuting the case ultimately. How when you were sort of the prosecutor in charge, I forget the title of it, was, let's say it was called Prosecutor of the Week. Officers, you'd come into your office in the morning and the officers would be sleeping on the floor outside the door, waiting for you to take their cases. Why? Because they saw something in you that they wanted to attach themselves to. I'm of a firm belief that many officers, and I'm talking about them specifically because this is, I think, the biggest part of our challenge and our opportunity as prosecutors. I remember pushing back on officers when I was a prosecutor, saying, I can't take this case forward. I can't prosecute this. I'm going to have to no paper this. One of the things that I would say, and again, encourage newer attorneys to say who are less secure in their positions, if there's a bad guy out there, if they're the bad guys, we'll get them again. But right now, this isn't sufficient for us to go forward. Pushing back requires giving officers authority. Meaning what? Here's the case. Here's the decision. Many times they would take that information, grumbling, and that's a euphemism, grumbling, and then come back an hour or two later and say, okay, fine. And so when I would come in and see officers sleeping outside my door in the morning, I thought, oh God, can't I just get a cup of coffee in first? But they wanted to work with somebody who believed in the work, who believed in their professionalism. And again, I don't believe that they joined the force to be awful people. I don't believe they joined to be horrific and to abuse children and sort of mow down, little old ladies in protest. I don't believe that's how they start. Something happens along the way. And certainly to the extent that you can represent something more uplifting, a higher calling for those officers, I have to tell you, you'd be surprised at how many would respond. So that's one of the things I would definitely tell them.
Yes.
I want to share this because there's a part of me that a lot of people don't know. I started my first job at a law school. I was a prosecutor. That was my dream job since the 5th grade. I am still in touch with my 5th grade teacher, and she's like, I saw this coming, right? But what happened was I rose in the ranks quickly. I tried cases. I loved my job. And then I had that encounter where a law enforcement officer was less than truthful, right? And here I am as a lawyer practicing less than 3 years in Polk County, which they had never had a black prosecutor. Here I come with my fist raised in the air, ready to say, okay, well, no, we can't do this. And it just did not work out for me. So I was caught between a spot where, can I call out this officer? Because he really did it in a very, like, it was smooth. I even to this day, I'm like, oh, it was pretty good. But I knew inherently, you know what's right and what's wrong. And I had to make the decision that I had limits. Okay, so the best advice that I can give to young prosecutors based upon my experience is, number one, research the office. There are prosecutors' offices around this country who they all have different mindsets. While less than 1% show the level of diversity of this country, the reality is the mindset is very different. So you have to look into all of the different ways that you can contribute to an office, because your job as a prosecutor is to fill out and fulfill the mission of the lead. So I expect the prosecutors who work in my office to fill out what I want to happen. So they have to get to know me. So even when I came out with my decision on death penalty, I really thought to myself, I'm like, okay, am I going to impact the people who want to work for me? You know, I want a high level of experience, of expertise, who may think differently, who may now not want to work here. So I have to think about that, which means that you are a valuable asset if you have the mindset, if you have the ability to try cases, if you have the intellectual capacity. You are an asset to an office if you take the time to research it. Now, once you get at the office, the second thing is to know your own limits. You have to know what your limits of justice are and how you define justice, and if a scenario happened, how you would respond to it. You need to know where your line is drawn in the sand, where no matter how many law school loans you have coming in, no matter what type of rent and or mortgage you have to pay, where you say, I don't care what someone above me says, I cannot continue to push more. So then you have to cut bait at that point. But then there's still other offices out there for you to do. There's more experience. So if that were to happen to you, you continue to maintain your fight for justice just in another avenue, which is exactly what I did. I became a public defender, and I started fighting, and I understood the human side of the system, where I spent days at the jail. I was there for almost 10 years, which means I tried every type of cases from a suspended license to a homicide. So the level of experience that I was able to get and insight, I just had to do it from another place. Then I started speaking. I was a professor at the law school, at FAMU's law school, teaching trial practice. So my experience began to grow, and guess what? Now I became qualified, more experienced to come back to the state attorney's office with more standards, with that ability, and ultimately qualified to run. If you're never interested in running, you now have the experience to join the team of someone who is interested in running. Because when I got ready to run, I wanted to know who was going to be on my executive team, who had the experience, the commitment, and the understanding of what my goals were. So the process is to research the offices you want to, know your limits, and ultimately get the experience that you need to get.
If I can just add, this is the second story about Judge Calabrese. You know, when I first started as a prosecutor, I had a long conversation with him about both the opportunity to do justice, but also my misgivings. And he gave me this great piece of advice. He said, and it's very much what State Attorney Ayala just said. He said, write yourself a draft letter of resignation and put it in your desk drawer, and assume that you will never have to take it out, but understand it's always there. When I first became a prosecutor, the state of Maryland had a death penalty. And I knew from the positions I had taken in high school that that was not something I could do. And if I was ever directed to do that, which the elected state's attorney would have been entitled to ask me to do, I would have had to tender my resignation. I would have first said, could you not give me that case? But you do have to draw those lines. You have to understand that at the end of the day, your principles may not always match up with what the law is, or where the law will be when you are in that position. But the other part of it, and I think this goes back to Professor Fairfax's question, is what do you do when you encounter a prosecutor in your office who doesn't quite get it? How did they get to that position the same way a police officer got to that position? And one of the interesting insights I've had over the years is I actually think a lot of What I learned this from was being a federal prosecutor, where we actually had to develop cooperators and turn our defendants into witnesses. Because in those conversations, they do it in part because their lawyer is telling them that this is the consequences and this is what you should do. But it's also because there is a relationship where you build a level of trust between the prosecutor and that defendant. You come to understand their story, their humanity. They come to respect your position, both in explaining to them that you're about to prosecute them for this crime, but also giving them an opportunity to find some measure of redemption. And that exposure to the humanity of the defendants is not something you get every day as a prosecutor. It's right, on any given Sunday, sometimes your defendant is a witness, sometimes your witness is a victim. The roles change quickly. And so you are exposed to them, but having an opportunity to really understand the path that they have walked, the life they have led, that got them to be where they are, I think can sometimes help soften what is otherwise a stiff, firm, unrelenting view that a younger prosecutor sometimes has.
I had the same conversation with Guido. I should add that
I thought I was special.
you were just the pioneer. I think it goes without saying, but I'm here in my personal capacity today and not speaking on behalf of the department. But I think one of the best ways to accomplish the things that have been mentioned is to ask questions. Ask questions of your agents or your officers, to ask questions of your boss, to ask questions of your colleagues, questions that are based in the cases and the statutes, questions that are based on the legal standards, but to say, so this is the case that you're bringing to the indictment review panel. Why is this the most readily provable or the most serious readily provable offense? What is your evidence to prove it? Because I'm not persuaded. And the more questions like that you can ask, and you cloak yourself in the policy or in the statute to say, when you're on duty and they call you for a search warrant, you say, well, I don't understand your probable cause. Can you explain it to me? That asking questions is a less threatening way to come at someone, whether they're your superior or a more experienced person in the office that you're dealing with. And it allows them the opportunity to self-reflect and to come back at you. If they do have the case, then they'll make it. And if they don't, they'll pause or they'll find someone else. And those are ways that you can, both do what you have been instructed to do by your boss, who may change, and to hold your ground, doing what you know is right.
So I'm interested in the relationship between the prosecutor and the legislature. There have been some high-profile examples, including with State Attorney Ayala, of prosecutors proclaiming that they would decline to prosecute certain categories of cases, certain crimes, whether they be low-level, drug possession crimes. And there are various rationales advanced for the enforcement decision, right? It could be a matter of conscience, disagreement with the law. It could be a matter of acknowledging there's been an unfair application of the law or discriminatory application of the law over time that you want to rectify. Sometimes it's a matter of resource constraints. You just don't have the enforcement resources to prosecute certain types of cases, and you would rather redirect your bandwidth elsewhere. Then the counter argument comes, well, the legislature passes a law, and laws are passed for many different reasons, but there's an expectation that those laws will be enforced by the law enforcement officers entrusted to do so. And on the other end of the spectrum, from perhaps a full enforcement model, is what Mr. Vignarajah said earlier, discretion, right? I mean, prosecutors have plenary discretion and are expected to make wise decisions, factoring all those other considerations. So I wanted to get your perspective on the proper role of the prosecutor, given that you can't prosecute everything, and so therefore you have to make decisions. But the prerogative of the prosecutor, if you believe there is one, to decline to prosecute for reasons other than simply resource constraints. You have a disagreement with the law, or you don't believe the application of the law has been fair historically.
Just say if you think it's not a good idea, just don't announce it publicly. I'm just kidding.
So I've read your prosecutorial nullification article, and I appreciate it. Absolutely, the prosecution has the discretion, period. And whether, there are all sorts of decisions that are being made in that realm of discretion being exercised. And so to the extent that your decision may be, for example, not to prosecute, it's baked into the cake. There is very little review of what prosecutors do. Almost, some would say, a criminally low level of review. Prosecutors are without peer, it seems, almost in this system when it comes to a review of their discretionary decisions. So the ability to make a decision is yours. The question is what decision you'll make, and if you know you can make it, and when you make it, and politics and everything, of course. But there are always decisions being made. One thing I would caution you about is, particularly when you're a lower level prosecutor, newer, your cases are curated for you. They're not curated by actual crime that's occurring. They're not even curated by your deciding that you want to take this case versus that one. On the basis of the section you're in, your level of expertise, what law enforcement officers seem to think is appropriate to bring to you, you have no idea how much is going on before you get a case. And so it behooves you to pay attention to, again, the context in which you are operating, the office in which you are sort of operating, and understanding that discretion has been exercised before you got the case. And certainly now that this case has made it to you, you may want to think about your power and your prosecutorial discretion that can, in fact, be applied to the facts. That may be the closest you can get to reform in some of the offices. Your ability to say no or to decline or to not push fast and hard for a particular case when it's called on the calendar, or to sort of allow it to sort of just languish. I mean, it happens all the time. It's not wise to announce it many, many times, but certainly it happens in the quiet corners of the office. You hear prosecutors speaking of it all the time. In fact, you even hear some law enforcement officers saying similar things. So absolutely, prosecutors are making their decisions separate and apart from what the legislative body has proclaimed and promulgated.
And I'll just add, and I think Professor Fairfax, mentioned these features. There are a couple of things that the elected prosecutor has in the conversation, let's call it, with the legislature. One of them is that they know their jurisdiction best. And sometimes their jurisdiction is different than other jurisdictions across a particular state. And the prerogative to say what may be working in a rural jurisdiction is not going to work in an urban jurisdiction. What may be working in a jurisdiction that has 100 cases versus a jurisdiction that has 10,000 cases. Those are differences that I think prosecutors are entitled to. The second one is that the legislature has the ability to pass laws that strip away discretion. And when they don't, there's sort of a tacit understanding that the prosecutor gets to decide. The last couple of years, the state's attorney in Baltimore City has advocated for mandatory minimums statewide. And in circumstances like that, I wonder out loud, what are we doing here by giving away some of our discretion? That's a dangerous thing to do because the legislature can tie our hands. And when they do that, it's almost like you could use the legislature as an excuse for what is ultimately supposed to be your decision. And the last piece of it, because it is not always supposed to be easy to do the right thing, even when it's unpopular, but you also know the particular facts and needs of a particular case. And so when you're a line prosecutor, when you're talking to a supervisor and recommending that you not proceed on a case or not proceed on a charge or recommend a sentence, one of the virtues that you have in that conversation is you say, ma'am, sir, these are the facts of this case. And I know the details of this case better than the supervisor does. And in the context, in the conversation between an elected prosecutor and the legislature, you're in a position to be able to say, you know, folks down in Annapolis or your state capital, you don't know what's happening in Baltimore. We have a different kind of problem. So if you want to pass a law that is relevant for other jurisdictions, so be it. But here in Baltimore, we have a particular community and a particular set of needs, and you have to give me the latitude to do what is necessary here in Baltimore. And pressuring prosecutors to do something because it's politically popular is a really dangerous precedent, and we have to sort of build up the muscles to resist that.
So let me just say for the record, I was joking about the whole. I was really joking because one thing that I said when I took office January 3rd of this year is I would make no decisions for reelection. I would do what I believed was right throughout my entire term, and I will continue to live by that. So I don't hide behind the whole goals for reelection. But what I will say is that when it comes to prosecutors' discretion, we have to remember our little civics class that I don't think they teach it anymore, but I mean the three branches of government. And as prosecutors, you're quasi-judicial, quasi-executive. So you do have some authority to administer. And if you look at the ABA rules, I think it's the model rule 3.6 and 3.8, it talks about a prosecutor's responsibility. And a prosecutor has a responsibility to engage in reform if they see. A prosecutor is not allowed to consider the severity of the offense as their success. Prosecutors who are administering the law don't just consider whether or not it is the law, so I must do it. They have to say, is the administration of this law the result? Will it result in justice? And that's something that allows you that discretion. That doesn't say that you are dismissing the legislative acts that allow that law to be in place. It says that I've looked at it, I believe it's the law. Now, is the administration of this proper? Finally, we have to consider the fact that whatever we do as prosecutors must take into consideration equal protection and due process. We can never forget that. So whatever we're choosing to do when we play games with people and say this case but not this case, we're going down a slippery slope that is embedded error for appellate review. So you have to be very mindful that if you're going to create a policy, that's actually better than to nitpick cases because you cannot distinguish why you chose that particular action on this case. And guess what happens? You do the case all over again and you can't do it the way that you wanted to. So you have to always remember when you're instituting policy and exercising your prosecutorial discretion, due process and equal protection.
I think that last point is really important. And, you know, this is a question about institutional discretion, the prosecutor versus the legislator. And in that context, I think we are better off when we have policies rather than ad hoc determinations. And that doesn't mean that there aren't exceptions, but that there should be a default rule that people are, you know, like in this office, we recommend the low end of the sentencing guidelines. And if you want to do something else, you need to get approval of your supervisor or whatever it is, so that the, you know, people who have committed the same crime in the same community are being treated the same, at least so far as you, the prosecutor, have control over that. And obviously the judges have control over that too. But, you know, you want to be doing your part to do, you know, that equality is part of justice.
So, you know,
can I just amplify that last point? Because I actually think this is something that especially younger attorneys don't appreciate about this. When I was a federal prosecutor, you sometimes have a case where, you know, you would think the application of a mandatory minimum in this particular case is pretty draconian. And that was my personal view, that was my professional view, and you'd go to your supervisor and say, how on earth are we going to invoke this federal mandatory minimum in this particular case? And you'd have the conversation, and at the end there was sometimes windows and opportunities to relent a little bit. But at the same time, one of the things that my early supervisor said was, look, it shouldn't also be the case that because you think that the sentence ought to be 2 years instead of 20 years, that's a good outcome. Because what happens then is you get this roulette wheel where a defendant spins the wheel, and depending on which prosecutor you get a 2-year sentence or a 20-year sentence. And that undermines confidence in the system as well. So the idea that there is some band that is appropriate, that likely, you know, similarly situated defendants are being treated in similarly situated circumstances the same, is really important for our trust and confidence in the system. And so I think that is something early on you don't quite get.
And to add to that, which is even more important, when there are inconsistencies in our criminal justice system, knowing that there's systemic racism, the default is it's a racial response. So you have to be very mindful that sometimes laziness or personal views of facts could end up with you being criticized of having a racial reaction. When I ran for office, one of the things that happened is, and this is a true story, there were two men driving literally on the same day. One was on one highway, the other was on another highway. They both ended up in a road rage incident where they pulled a firearm on a person because they had road rage on two different highways. One was a white male, one was a black male. The white male ended up in a diversion program, and he ended up having it reduced to an improper exhibition of a firearm. The black male had the 3-year minimum mandatory and is sitting in prison today. Do I think that that was racism? No, actually I don't. But there's a concept of systemic racism that is very real in our system. And because of that, when you don't have a justification for any distinctions in sentencing, it's going to be racially based.
Can I just add?
Yes.
Attorney Ayala brought up this whole notion of a gun, and I was thinking about this example in my head, and I thought, maybe. I remember one case where essentially we had a policy in the office that everyone who was brought in, arrested for a gun crime, we had to talk to them to make sure that the gun was coming from this location as opposed to that one, and they owned it, et cetera. There was a defendant who just simply would not, and he was a glowing, shining member of the community. And he simply was not going to submit to it. But the office policy was, you've got to submit or we go to trial. And I reluctantly took the case to trial. And all along the way, the office was pushing, you've got to do it, you've got to do it. That was the policy. But even then, when you have sort of this kind of mandatory policy, there still are possibilities for you to sort of do the thing that you consider to be more in line with justice. When sentencing came, because he was convicted, when sentencing came, the judge looked at me with horror because the defense counsel said very plainly, we're going for jury nullification because of his upstanding position. And the judge looked at me asking about whether I was going to ask for any conditions of release. And I said very clearly, Your Honor, we're not asking for any time. And please know that going forward, as the sentencing report is crafted, we're not going to be asking for any jail time. It was bad enough that he was going to have a felony after having this amazing life of contribution. So there still are opportunities, even when the structure seems to sort of not work in favor of the concept of reform, even if the system requires you to sort of, again, take these tough positions that may go against your own personal understandings. I'm not sure if my determination to step outside the policy would have been a better one. But certainly to the extent that I could affect some change, some assistance for someone in this terrible position, again, you've got to always look for those opportunities, even when it seems like your hands are tied. They may not be actually.
So my last question before we open it up to the audience to pose questions to the panelists has to do with the tragic instances of police killings of unarmed individuals, many times African Americans, have been covered in the news, and the seeming inability to obtain indictments in many of those cases. And there is a bit of a debate raging within the progressive sort of reform prosecutor community because one of the prescriptions has been to emphasize the need for independence of prosecutors to investigate those cases. We need to bring in an outside independent prosecutor because there is too close of a nexus between prosecutors in the jurisdiction and police officers in the jurisdiction. And then you have some vocal people within that same progressive prosecutorial community that say, well, no, in fact, we need to handle this in our office. We're equipped to do it. And in fact, there is value, symbolic and otherwise, in having this office handle it. One example of that is the late Ken Thompson, who's the Brooklyn DA, who was adamant about the need for his own office to handle those cases and to not cede that function to an independent prosecutor. So I wanted to get your perspective on that question, whether those cases should be handled by the prosecutor in the jurisdiction, or if you would advocate for the independence of the investigating and prosecutorial authority in those sorts of cases.
The default in the federal system is for an independent agency to do it. So if a law enforcement officer from a jurisdiction, a federal officer who's stationed in one judicial district is either a victim or a defendant in a case, the general default is for some other U.S. attorney's office or a component of the criminal division to take the prosecution. I think that works well, especially to avoid issues of bias in the prosecutions, because you're bringing in people who just don't have a personal relationship with the officer, whether he's or she is the victim or the defendant. It just, I think, creates a cleaner process.
Attorney Ayala mentioned that moment when you lose your innocence as a prosecutor and you realize, oh my goodness, we had an ADW against a police officer in our office. My next door neighbors were prosecuting the case. When such prosecutions are undertaken, when the law enforcement agency that you're working with is the subject now of your criminal prosecution, careful. It was disturbing, it was heartbreaking and disappointing to see how the force rallied against not only the officers who were part of the sort of witness list who actually testified, but the prosecutors who were charged with the case. It was heartbreaking, so disappointing. There was only one officer who said, "Listen, I've been in situations like this. No way should a suspect end up like that." If there is going to be sort of an in-house, and you develop these very close relationships with police officers and investigators and forensic specialists, if there's going to be some sort of in-house prosecution, the leadership has to be clear about what it is that they are doing. There has to be one or more unimpeachable prosecutors who are charged with this effort. They have to be given levels of support that allow them to do their jobs in a way that will bring forth justice, whatever the jury decides. The intimidation that can come from being ostracized and alienated, it's significant. And again, I know my innocence was lost. I know theirs was as well. So if there's going to be in-house prosecution of law enforcement officers under these circumstances, be prepared. If you're leading the office or if you're part of that office, even if you're not involved specifically in that prosecution. Another thing I just want to say as an aside, I find it incredible that prosecutors can't get indictments. I don't understand that world. The only way that happens, in my understanding, is if they don't want the indictment. So the inability to gain indictments over and over and over and over again, to me, it says something other than the evidence doesn't support that level of activity to move forward.
This is a really hard question, and I think there's good arguments on both sides. On this one, ultimately, I think I have to disagree a little bit with Sonja. You know, these cases tend to define for the public the relationship between the community and the police. They're really important. They get sort of outsized implications for what people think of the criminal justice system. And the idea that that has to be transferred to another body itself sows and encourages this notion that there's too cozy a relationship between police and the prosecutors that work with them. And so I actually think it's a mistake overall to do that. In certain circumstances, it may be appropriate because, you know, it's a major in the police department that's involved, or there may be certain circumstances where outsourcing it, may be appropriate to an independent prosecutor. But I think as a general policy, the prosecutor who is responsible for that jurisdiction ought to take responsibility for that particular case because they are so important. There are certain principles that have to govern those cases. They have to be, they have to be especially insulated from the politics of the moment. You have to really focus on the evidence and take the case to wherever the evidence leads, no matter the consequences. State Attorney Ayala said that you don't do these things for re-election. I think that's right. Sometimes you make a decision that is so unpopular, even though it's the right thing to do, it means you won't get reelected. And you have to understand that that's the cost of doing business, that you didn't get into this work to get reelected. You got into this work to do justice. There has to be a measure of transparency, where if you are not going to give it to an independent prosecutor, the public has to know, the media has to know, the police department has to know that you are dotting your I's and crossing your T's, and you're not doing this for the sake of re-election or the politics of the moment or for some other ulterior motive, but because the circumstances of that case demand a particular decision, and there has to be a level of deliberation and patience. There has to be a comfort with understanding that in cases like that, that are high profile, that are particularly complicated, you can't do it overnight. As much as there is pressure to do that. I have, taken the position that if we had a police-involved shooting or murder on my watch, that I myself would lead that case because of how important it is. You want to make sure that the I's are being dotted and the T's are being crossed. And at the end of that investigation, if charges are appropriate, then it's appropriate for us to hold accountable the police officer who is responsible. And here is the thing that everybody should know, which is the law enforcement community wants criminals among their ranks to be held accountable too. There are a lot of good cops that do hard work, dangerous work every day, and they ought to be our heroes, and they don't appreciate another officer dishonoring the badge, making their job more dangerous, any more than the prosecutors, any more than the police should. But that level of transparency, that level of trust to know that the person is going to do it and do it right, and do it for the right reasons, I think is really important. And so, Sonja, no disrespect on this one, I actually think that having an independent authority do it carries implications and assumptions that I think undermine the kind of trust we need to restore in the community.
I'm actually going to side with Sonja, and I'll say this. There's a couple of things going on here. There's a difference between what we desire to do and where our heart and mind think that we can do and what we actually have the capacity to do. And once you have set yourself and drawn a line with law enforcement, you're already seen as the bad guy. And there's almost nothing you can do to repair that. So your consistency is one of the most important things that matter. And the best way to manage it is to have an independent agency investigate it, and you all both take the result because you're no longer working together. The problem with doing it in-house is a couple of things. You have a reputation, you have things that people think that they know about you. This becomes a media circus, and we all know what happens with cases that are in the media. People start hearing things. They know everything about the case, even though there's work product. I'm still confused how that happens. So everyone has their opinion about a particular case, and even people within the office think they know what's going on with the case. And the reality is the attorneys who are handling the ones only understand the evidence upon which this decision is made, right? So when you end up having a case that you're prosecuting for a shooting or something of that nature, it even just be some type of violence with law enforcement, it's very important to have a situation where you are away from it to gain your dignity and your respect so that you are continuing to fight justice. Because what happens is when as a prosecutor, you're in the fight. And people end up defining what that fight is for you. You're either fighting justice or you're fighting against law enforcement officers, right? So if you are a reformed prosecutor, you have to send the message, I'm not fighting against law enforcement officer. I'm fighting against crime. I'm fighting against injustice. I'm fighting against mass incarceration. I'm fighting for justice. And the way to do that is to never be in the light of making someone think that you're fighting police officers, because at the end of the day, prosecutors need police officers. No matter how reformed form any prosecutor tries to be, everyone wants the murders, the carjackers, the robbers, the violent people out of our cities, out of our communities. We want them out, period. If it's your next door neighbor, if it's your sibling, if it's your cousin, if it's your coworker, we want them out because we all want to be safe. And the only way to do that is to utilize the investigations that are conducted by law enforcement officers. So if you ever appear to be in a fight with law enforcement officers, which, I mean, I take it, whatever, but I mean, if you ever appear to be in a fight with law enforcement officers, the best thing that you can do is not perpetuate that mindset and get into the media circus and make it about you. You have to make it about justice. You have to make it about fairness. You have to make it about transparency, because no matter what, when that case is on the television, not like all day, locally or nationally, every person thinks they know what's going on with that case. And you're going to be judged when most of the time there's 2, 3, maybe 4 people who actually know the content of that case. And you become the person being critical. And to take that away from you, you end up taking it away from your line attorneys. Because I'm very conscious that no matter what I get involved in, no matter how big it is, guess who may suffer? My line attorneys. And you have to think about that. Remove yourself and let the independent agency make the just and fair decision.
Thank you. So
like
I'd
I
like
said,
to,
reasonable minds can disagree.
Yes, absolutely, as always. I'd like to open it up for questions. I'm told that you need to wait for the microphone, and we have one right here.
First of all, thank you so much for agreeing to be on a panel and bringing your really well thought out ideas to this important discussion. So thank you very much. So we talked a lot today, you talked a lot today about, the Spider-Man's dilemma between power and responsibility and between discretion and consistent outcomes. I'd like to know if there are any concrete policies, prophylactic rules, external oversights that you would impose on yourselves to ensure that discretion isn't used waywardly. And if there are, maybe then talk about your vision of the prosecutor's offices 10, 20 years from now. Is it a reduced role that is cabined by informed policies and rules? Is it an expanded role, but with, carbon copies of progressive folks like you who are wielding their discretion in the right way? So I just wanted to know your thoughts on that.
I'm glad you asked the question because, believe it or not, even though it may not sound like it, I know each and every one of us is cognizant of how far it can go off the rails and the other way. We're very, very clear about that. One of the things I would suggest is you have someone in the office you cross-check your conclusions and concerns against and with. There has to be a level of trust there for sure. And you've got to respect the person's opinions and conclusions, even if they disagree with you ultimately. Having one of the great things about being in many prosecutors' offices is you've got such a high level of thought process there. And there's so many doors, potentially, not all offices, but potentially, again, going to City Attorney's point. Be careful where you show up and where you offer your services, because you want to be in a place that you feel respected and you actually respect what's going on. So cross-checking with others, second-guessing yourself, asking tons of questions. I absolutely agree. I absolutely agree with Sonja's, yes, it was your point, Sonja. The questions are every single thing. You don't have the conclusions. You have the questions. And it's one of the things I tell my students. Those are our tools, and this is what we do. And so questioning everything is so important. I don't know how I envision prosecutorial offices in the future. I know they will all need to have the human touch, for sure. I'm not so confident that our conversation will evolve along with science and sociology. I know that being tough on crime seems to never, ever go out of style. So I think oftentimes we're going to have to show up sort of making it clear we're able to do the tough job, but maybe not carbon copies of who we are, but certainly iterations of those who still believe in justice for all. I think that's what I would hope anyway.
I think it's important for all prosecutors, reform, traditional, whatever you'd like to call them, to understand and have clear goals. So without having goals, that means that you haven't identified the problem and therefore identified a solution. So one of the things that I have done is that every week I meet with my entire team. I explain to them what my monthly goals are, and they tell me how they're going to implement those goals. I intentionally have people on my team who disagree with me, very close with me. And those are conversations that we have. We always agree on what the problem is, always. We frequently agree on what the solution is. Our discussion is the process by which we link and respond to that problem with our solution. That's where we have the conversations that take a lot of time, it gets tense, and we get there because there's so many factors that we have to consider. Feelings, we have to consider the timing. There's so many things that need to go into that. And while I'm the ultimate decision maker, I can never, ever think that that responsibility rests solely on my shoulders. So it's the humility, the humanity, and setting goals is what makes this work and what I think will continue to make it work years up the road.
I think that there is an important process of tying yourself to the mast in these cases, because the hard cases are the ones at the margin where you think, gosh, just for this case, we need something. And so it's a really important question to say, what policies are you prepared to put into place to make sure when you get to those tough cases, you don't get tempted to use some tool that you think is otherwise, because then it's the next case and the next case and the next case. I think State Attorney Ayala, put it well about the general piece. I heard a former prosecutor say that fighting crime is both a marathon and a sprint. You do need to take each individual case with the seriousness and sense of urgency that it needs, but you also need to know that these changes are not going to happen overnight. We're not going to, stop all of the killings overnight, but there does have to be a sense of urgency. But with respect to specific policies, we're at a point in our history where there's a lot of things that ought to be pretty easy. No more mandatory minimums. No more life without parole for juveniles. The cash bail system is a colossal problem. Those are the easy ones. Then when we get to some of the harder questions about whether or not we should have police prosecutions handled by the office, by an individual, those are ones where we're going to have to look at a particular case, and one office can have one policy and another office can have another policy. But there's a list of relatively straightforward policies that states' attorneys' offices, that DA's offices ought to be adopting today. Frankly, they ought to be adopting them yesterday. There's cases where Maryland is to the right of states like Kentucky. And I think to myself, how did we get to a place where we're sitting here debating whether some 16-year-old for a heinous crime ought to be subject not to life in prison, but to life without the possibility of parole in prison? So those are some of the debates that, that have been languishing in some respects for the past couple of decades that ought to be the easy calls. And in those easy calls, we ought to be able to tie ourselves to the mast and say that is our policy and we do not breach it.
So I think I have two easy answers for you, and then one point of disagreement. The first is that record keeping and data can be really helpful. So a number of trial attorneys I know keep personal records on every case they indict. Who is the defendant? What is their race? What was the drug quantity? What happened? And then every year they go back and look and say, what was I doing this year? Was I part of the problem? Was I part of the solution? And so I think that's something that people can do independently. That's something that offices can do. That's something, that it's great that we do systemically to look at the data and continue to look at what the statistics are telling us. And along that lines, the implicit bias training, I think, has been really helpful. You see a lot of law enforcement agencies doing it, and prosecutors should do it too. It's something that, anybody can do on their own without, it doesn't have to be a big formal thing. You can just go online and take the little test. But just being aware that this is a thing and it's in all of us, and everybody, as the song goes, everybody's a little bit racist. And just knowing that that's in you is, I think, goes a long way into helping you see it in what may be there. But the one point of disagreement I want to say is, I think there's a way that you can tie yourself to the mast, at least as a community, through mandatory minimums. I think that's the purpose of them, is to say that we as a community have come together and said that this crime in these circumstances is so outrageous that there is no other appropriate punishment. I think we went overboard in the late 80s and early 90s, clearly, but I don't think that means that the tool is inherently inappropriate. And for something like the use of a machine gun or the murder of a child in a sex offense, that those are things that maybe a mandatory minimum is appropriate for.
Yeah,
communities should get to decide.
Can I, just because I think our judge would appreciate this. Actually, why don't we ask a question, then I'll debate with Sonja later.
Okay, we have one over here. You need to speak into the mic, unfortunately.
Thank you all for this great panel, especially State Attorney Ayala. Thank you so much for your work and who you are. It's really an inspiration to a lot of us. My question actually goes back to a discussion that you all had earlier about communication around elections and campaigning. And Mr. Vignarajah, I think you mentioned, proposing another way, outside of the kind of tough on crime, mandatory minimum rhetoric. And so my question is about that. Would you, and Ms. Ayala, do you think that prosecutors do you think that you all would take a more proactive role in espousing violence reduction strategies in your jurisdictions, taking a more proactive role in public safety? So outside of the office, getting on board with, evidence-based violence reduction programs that are less punitive, like Cure Violence or Ceasefire, those kind of things. Do you think that that's appropriate for prosecutors to do? And then internally within your own office, getting to the data question, Sonja, do you think that it would be something you'd be interested in and also focused on to look at recidivism rates as a measure for your prosecutors, not just convictions or even just racial disparities, but to have prosecutors take a different role in interacting with crime and conflict by seeing how their decisions ultimately impact future crime. So take a different role in public safety in that way.
Absolutely. That's exactly what the concept of reform is. So when it comes to recidivism rates, since that's the last thing that you said, in Florida, for example, the numbers show that every person who was sentenced in 2015 will be released by 2020. Okay, and it also shows that a quarter of defendants who are sent to prison are going to recidivate. Okay, so we have to know that today's sentence must consider tomorrow's release with what we're doing and being involved internally. So recidivism rates and keeping those numbers are absolutely something that prosecutors should care about. We shouldn't just care the day of sentencing. We should care the day of the next crime or the next day that crime was prevented because of our sentence. The second thing is that when it comes to involvement, my office actually is involved in Ceasefire. When I ran for office, I ran on a community outreach and education component. I have appointed a deputy director who runs my community outreach, and his sole responsibility is to be involved in community actions, because if we're really interested in public safety and reducing violence, we can't just run our mouths about it. If we're really interested in reform, we can never ever eliminate the concept and the discussion of reducing crime, because reducing crime, especially violent crime, is how we get our recidivism rates down, is how we get our incarceration, the mass incarceration reduced, is how we actually turn this thing and get it going in the right direction, at least for a period of time.
It's really well put, and it's a really important question, because in Baltimore City, the rate of recidivism within 3 years of release is something like 73%. So 73% of the hundreds, thousands of people that return to Baltimore City every year will reoffend and be reincarcerated within 3 years. That is literally the definition of a revolving door. And to try to break that cycle, you can't prosecute your way out of it. We know we can't arrest our way out of it. We have to acknowledge some of these broader issues. Frederick Douglass, in 1855, famously said, "It is easier to build strong children than to repair broken men." And the idea that somebody had that insight and wisdom 5 years before the American Civil War, which is as true, if not more true today, ought to give us pause about how basic these concepts are. And so the idea that we are going to be able to fix this problem without going and acknowledging some of the root causes is just, it's laughable. We just can't do it. At the same time, the budgets of prosecutors' offices compared to the budgets of some of these other agencies are completely dwarfed. There's only so much you can do with your limited resources. So you do need to understand that your responsibility is to hold the criminals that perpetrate these really violent crimes accountable. And at the same time, in the same breath, try to spearhead some of these reform-minded initiatives like ceasefire, like juvenile justice reform, that are absolutely essential. The reason I take a different position than Sonja on mandatory minimums is because the cases for which we would all agree that a mandatory minimum might be necessary are frankly the cases where I ought to be able to walk into a court and ask for the sentence outright, because they are really, really heinous crimes. And what ends up happening is that if you use mandatory minimums as a shortcut, it allows the prosecutor not to have to make that individualized judgment in a particular case, but it also sends a signal to the community that the playbook of the 1980s is still on the table, and that undermines the broader reform efforts. And so it's not just that the policy is not necessary, it's that it comes with a cost. And it's a cost, frankly, that's been borne by communities of color for the last 40 years, but now it becomes a cost every day going forward. And so I think you're 100% right that we have to keep our eye on the ball, and I'll just repeat it before. That is, I think, what that former prosecutor meant when she said it's not just a marathon. I mean, it's not just a sprint, it's also a marathon.
So I've been told we're down to the last 5 minutes. I'm going to take 2 questions because I made a promise that I'd recognize 2 individuals, and then we'll have the panelists respond to both questions. So one is right there in the back.
So one of the parts of the cycle of law enforcement that people talk about is community-based policing. And they say that, well, one of the things that brings up inherent bias is, say, that the cop that walks the beat no longer lives in that community, is no longer part of that community except when they are on duty. So the question I have for the panel is, as the prosecutor, since in many cases, when it involves something, when there's something that involves the police or there's something that involves a heinous crime, your name, your face, your person is the specific entity that is put on by the community, that's put forth for the community and put forth by the media. What is your role in the community, not just as a prosecutor, but as a person? Where do you come in terms of how you live your life to be informed in the, so you're not looked at as the persecutor, but more as a part of that community?
And then while we tee that question up, we have one additional right there.
My name is Herbert Brown. I'm a graduate of Howard University School of Law. One thing I'd like to say is that, you know, we're focusing now on prosecutors because you're having more prosecutors of color and more female prosecutors, head prosecutors or district attorneys, state attorneys. I think that what we haven't spoken about is a failure of the state legislatures themselves to take, to be brave enough to say, listen, we have police officers who are killing people, and there has to be something that's done. To say that, and Mr. Vigno Raja, I applaud you for saying, look, I can do it, before I got old, I used to think I could do everything also. But sometimes I think that what we need to, my question is, when does the state legislature, each state legislature, become responsible for providing a mechanism where the bad guys, regardless of who they are and what uniform, what type of clothes they wear, are treated equally as bad guys? We must remember that when you kill someone, there's a life that has been lost. There's a killing. If it's a wrongful killing, then it should be prosecuted. To ask, and I agree with you, Ms. Ayala, sometimes I don't know if the prosecuting office can prosecute the officers or the police department, which they work so closely with. Maybe you need to have a police court, which has to come from the state legislature. Maybe you need to have, I don't know what you need, but you need to change it because people getting killed when they have, what's the electric thing they shoot you with? The taser. Why can't they tase them? I don't know. I mean, I don't get stopped. I don't get shot. Well, I live in New York, so I can't even drive my car. So we're all on some mass transit. But the point I'm trying to say is that we're taking it from police officers, prosecutors, but I think that maybe in each state, maybe the state prosecutors of all the counties need to press the state legislature for laws that are going to be more, that's going to take care of the people. The police, the bottom line is the police are here to protect us, not to kill us. And anytime I see, regardless of the color of the police officer, that a person has been killed by the police, it should be a situation where it was life and death on his or her part. So I'm just asking, why don't we, I just think that you may need to, like you said, Ms. Ayala, you have to look at your staff. I think that you may need to separate that function from the prosecutors and do something else. I don't know what it is, though.
All right, thank you. So if you'd like to address either of the two questions.
I'll try to sort of combine the questions. Prosecutorial involvement is significant, should be significant in all of the cases. You can't do it all for sure. But if you are prosecuting in a community you know nothing about, I would suggest that you stop that immediately. I think you need to literally go to the crime scene. I know some of us, particularly many of us, when we become prosecutors, we're given the drive along, and it's so lovely, and it's nice and crisp and clean, a little rugged, a little dangerous, not too much. I think you need to go where your officers' cases take you. If that means you have to traverse a forest in heels, if you have to take your good suit and crawl in some dusty little corners of some place. Did they really see that from the lookout point? Is it really possible to run, you bring your watch and time it, 15 seconds to get from point A to point B? I mean, that being unaware of what you're doing it's a crime in and of itself. Luckily, not prosecutable for us. I mean, because again, but you should be aware. You may be standing there in front of the court making arguments that make no sense. And then again, when you talk about the credibility in the community and people paying attention to sort of the prosecutor's office and holding it to a standard, you may not know that you're setting yourself up. So being involved, boots on ground, in parades, at grocery stores, daycares. I mean, you have to be there to be credible. When it comes to police shootings, and again, this is almost the same answer, being aware of what that means, I think we miss what that means. We're inundated with these cases, unfortunately, and we hear a person who's killed. But you don't think about how that person is a dad, or that person is an aunt, or that person is some amazing or not so amazing contributor to the community. There are others who are standing, barely, devastated, totally by the loss. And even if it's just the notion that people like me or people who look like me could be plucked out of existence simply because, and there's not even going to be an indictment to march us through even the procedural representation that I should expect. That's devastating to prosecutors' offices. That's devastating to communities, and communities you wouldn't expect. There are many of us who don't seem to be the subject of stops and who haven't been shot by police. You don't realize how much that reverberates in the bones of even prosecutors. Famously or infamously, Paul Butler, who was a special assistant U.S. attorney for D.C., who's now a law professor, recalls in his scholarship how he was the subject of some inappropriate policing. So this kind of conduct doesn't just end with the shooting and the killing of fill in the blank of the person's name. These killings are destroying us, our society, the fabric of the society, the credibility of our institutions. The people who are left standing, we are the walking wounded. We are the walking wounded. We're involved, even if it's just as observers. So I would just say, being very conscious, I don't think you have the luxury of being ignorant and uninvolved as a prosecutor. I think, in fact, if you feel that you have that luxury, you probably should try a different way of sort of conducting yourselves, because there are people in those communities. I always thought community policing was interesting and going to community meetings was interesting because, you know, I thought that's a nice thing to do, but don't people want the same thing? Great policing, to feel safe, to be able to play in their neighborhoods. That's a little simplistic. I would say your presence matters. Even if you think it's just an exercise in futility, even if you think it's just some sort of dog and pony show, you would be surprised at how much you gain and learn and become respected because you are showing up. And showing up, I think, is important. And remembering that what happens up here affects everyone in the realm.
So I want to address both of the questions. Now, your question about police shootings and things of that nature, I think, and this is total soapbox, like prosecutor right here. When it comes to us as prosecutors, we can never, ever lose our humanity. That's who we are, and that's who we serve. When you think about the people who are caught in the system, at the end of the day, I don't care if you're sentencing them to life in prison, they deserve a level of human respect just because they breathe the same air that we do, okay? So when we start thinking about us as human beings versus us and them, we have to remember our consistency as human beings is contagious. When we start tolerating lies, when we start contributing to misrepresentations and lack of credibility and playing the game, we should not be surprised when it looks us back in the face. So what has happened over time, it's one of my favorite quotes, especially after becoming a prosecutor and being elected, is that for those of us who fight monsters, we must be careful not to become one ourselves. And that goes for law enforcement officers. When you fight negativity and evil so much, you often begin to expect it. And that's how we end up with people shooting and not giving someone the chance to see who they are because they don't want to be shot. So they're going to shoot first. So we end up in this situation. And to go to the first question about being involved in the community, that is exactly what keeps us grounded and keeps us, rooted. We just had the Hurricane Irma come through Florida. Where was I on Saturday? I had my 3-year-old and my 6-year-old, my husband. We went out to one of the parks that were serving food to people who had lost their food, electricity, and things of that nature, just to walk around, to thank people. I mean, granted, I had to leave because I smelled weed, but at the end of the day, you know what I'm saying? I'm thinking to myself that these are all the things that we have to be aware of by being well informed. But if we take nothing away from this, we have to understand our consistency, our credibility, our humility. Those are the things that make us human, and that's what will permeate in society. We have a responsibility to get violent people off the streets. We have a responsibility to make public safety our priority, and we must do that with a level of human respect that makes our system the most respectable in this community.
These questions, I think they're great questions. I don't know that they speak much to the federal system as much as they do to the state and local system, but I think one thing that's important is for prosecutors of all types to be working with legislators, because the legislature is the voice of the community. I mean, that's, as Ian said at the beginning, that's how our system is set up for Congress or for the legislature to come together and make the laws. And, maybe it's time for Congress to reevaluate the civil rights laws that make it hard to get indictments without showing a purpose to deprive someone of their civil rights under color of law. That intent element is really hard to show, and that's one reason that it is hard to get an indictment. And I know that state laws sometimes provide an affirmative defense for officers involved shootings that make it hard to show the level of intent. And, maybe that was right for a time before, maybe it's still the right answer, but maybe that discussion needs to happen. But that discussion can't happen in the prosecutor's office. It has to happen in the legislature because the statutes define the crimes. You know, we're not a common law system when it comes to criminal law. And so it's important for people to go out and lobby their legislators to talk with their members of Congress or with your state representatives and say, you know, these things are important and we ought to have a conversation around it. Prosecutors need to be a part of that conversation because we do have, you know, that insight, but it's a whole community question of all of us coming together to voice our values through our laws.
You know, I think prosecutors gain their humanity from different things. For me, I was the product of public schools. My parents were public school teachers. I had a sense of the community from a very early age. But you shouldn't use that as a reason not to understand and continue to understand the community that you serve, the community that you're a part of. It's not just about understanding their humanity, although I think that is likely the most important thing, to really understand that as you are doing a very hard job of asking for a very stiff penalty for a person who did an incredibly heinous crime, that you do not lose sight of the fact that they too have a mother and a father. They often have children. Early on in my career, people would ask me, God, you seem to really love being a prosecutor. You know, what's the worst part of the job? And I would say, you know, I'm sometimes in a courtroom doing what I believe is not just my job, but is also the just thing to do. And I look over my shoulder, and in the back of the courtroom, the children of the defendant are there. And I am asking for a life sentence for a 27-year-old or a 17-year-old who killed a 12-year-old and shot 3 others. And I think to myself, is the next generation of my defendants sitting in the back of this courtroom? Because we are doing our work at a cost. It is a cost that I think is worth it in some cases and not worth it in many others. And I think the humanity that we gain as we grow up, as we continue this work, is really important. When I was a prosecutor, I used to go out to the crime scene, and I would try to put myself in a vantage point. What I would tell the police officers, because sometimes they would say, you know, you seem to be asking for something that most of the prosecutors don't ask for, or why are you doing this? And it wasn't just because I wanted to double check. That was certainly part of it. But it was also because I thought I could be a better prosecutor. When I got into the second floor of an abandoned location where the police officer said he saw a deal take place or a gun in plain view, I would be able to confirm that they were able to see it, and then I would take a photograph from that location so that the jurors could see it too, so that they could have confirmed and corroborated the respect that I had accorded to the police officer as well as to the defendant, because they both are entitled to a presumption of innocence, a presumption of trustworthiness, but we trust but verify. And that is, I think, part of what we do. I will end by saying that we are at a particularly extraordinary moment in the history of criminal justice. There are cities that are being ravaged by crime, but there is also this momentum to try to do something about it that isn't just mass incarceration or zero tolerance. And I'm of the view that if, you know, people like State Attorney Ayala and others across the country are able to prove that we can both reduce crime and hold criminals accountable, whether they're police officers or gang members, and at the same time acknowledge the humanity of this system, that blueprint will become the blueprint for cities across the country. And the experiments, the laboratories of innovation that are happening in local jurisdictions ought to be a template that we replicate and that we duplicate and that we expand. And I hope you guys are as excited to contribute to that as I think the people on this panel are.
I just want to say one last thing. We've all mentioned the concept of humanity, and what follows it is the person being charged committing the crime. When I ran for office, and what we have to remember is we represent the human beings who have been the victim of crime, who often are not considered because of where they come from, who are often like minimized and demonized because they may have been a defendant the day before. These are people who are witnesses who need to understand that they are respected because they're the ones who make our cases. No matter where they come from, no matter what they've been through, no matter what, they are the people that matter in this system as much as the defendant. So while we talk about a defendant's due process, we talk about treating him or her in a humane manner. That is all important. But the key to the humanity of us as prosecutors is never, ever forgetting that you are creating a case based upon a human experience. People who have had firearms in their face. People who have been driving down the street and ended up with their cars taken off by someone else. People who have been shot by police officers. People who have been anything like beaten, watched their parents get killed. All the things that we see, that is the very thing that keeps us going. So while we have the conversation as reformed prosecutors thinking about the system, we can never, ever forget that the focus must always be on the community and the victims that we are saying we serve. And that's what really matters, is the victims in this situation and the communities that they come from.
Well, this 90 minutes or so went by very quickly, and I suspect had we had another 90 minutes, we still would only be scratching the surface. This was an illuminating discussion. I want to thank all of you for participating, and I want to ask the audience to join me in thanking our panelists.
Again, I want to thank the panel for this fantastic discussion, as well as our partners at the National Bar Association for co-sponsoring this event, and Jenner and Block for their generosity in hosting and feeding us today. A quick reminder that ACS is a 501c3, and it does not endorse nor oppose any candidate for elected office. Finally, I want to thank all of you for coming out and joining us today, being a great audience with really fabulous questions, and to encourage those of you who are not already to get involved with the American Constitution Society and or the National Bar Association. Thank you very much and have a good day.